Good afternoon. I wanted to share a few pieces of information that may be of concern to some of you out there. Last Friday, as I previously announced here or indicated on Facebook here, as of last Friday, pursuant to orders of the court entered in both of my litigations. In the Kenton County Family Court, my litigations will not be being handled by that court. And there were orders entered, identical orders entered Friday in both cases. I wanted to clarify a couple things about some of the factual statements that were contained in those court orders so that they do not generate confusion. The first is that the suggestion, such as I read it, that the issues that I have spoken up in relation to that have been the substance of the subject matter of my Facebook videos for the past 6 months or something, that those issues were at some point in time addressed to any commission or investigative or disciplinary entity of any kind. They had not been. There was reference in the court order to a certain motion for recusal that was filed at some point in my cases. That was a long time ago, had nothing to do with the substance of the Facebook videos that I put together for public consumption over the past 4 or 5 months. And in fact, that motion was made quite some time ago, and prior to the issues that we're now talking about had even come onto the radar screen, certainly before they had ever been publicly discussed. So I wanted to clarify that. I'm not sure what the basis of the court's belief, as stated in the court order, is for the fact that these have been, in some way presented to anyone other than law enforcement. I've been transparent from the beginning that I did at one point report certain things to the authorities who are charged with maintaining the integrity of our public institutions. And I've mentioned that before, and we've had several meetings, with them, more than several. And at the last court hearing prior to the court's entrance of one of the last hearings, just prior to the court's entry of its recusal, in both of my cases, there were representatives of those, or a representative of those law enforcement agencies present. That's the only steps I've taken. I have not availed myself of the various things that exist in the law or that are related to the law and the practice thereof, from that relate to the mechanisms by which you can complain about judicial conduct, the mechanisms by which you can complain about private attorney conduct. I haven't said that. That's not something that I've done for the simple reason that it's not consistent with the mission, which is to affect positive change. And again, I've said this many times. I have no interest in having anybody's head on a platter. I have no interest in punishing anybody for God knows what. I have no interest in anything punitive or retributive like that. The purpose, in a very disciplined way, is positive change, and has nothing to do with me personally, and nothing to do with my cases. This is changing a public institution and reforming it to serve its public mission. That's it. So me taking private action to settle scores or do anything like that is stupid. I don't believe in it, and it's just wasted time. So I wanted to clarify that because the court order, could be read to suggest otherwise, and I don't want there to be confusion about that. The other issue that I wanted to kind of speak to briefly was there was some mention in the court order of some kind of threat that I made to judicial staff or persons affiliated with the litigation, and I just wanted to speak to that briefly and say that I wouldn't. I put a video on Facebook. The video speaks for itself. I stand by the video, both in substance and in tenor. It is true that I am, or I was, one of my lawyers, pro se attorney but it remains that I remain that I'm a pro se litigant, and I'm a party in the case. So obviously my private Facebook or my Facebook posts are made in my capacity as a parent, obviously not as an attorney. I think that that's pretty obvious from the tone, tenor, and subject matter on the whole. And those posts far transcend anything legal to speak of, kind of the parental considerations involved in divorce parenting and issues like this, and the unfortunate nature of having disputes between parents in the form of litigation characterized divorced or separated parenting arrangements. So I just wanted to clarify that obviously my Facebook videos are have been and will continue to be made in my capacity as a parent. It is the case that I'm a parent that happens to be a lawyer. I'm a parent that happens to be a former federal prosecutor, and make no mistake, that experience on both fronts and that knowledge has been helpful to me as a parent in coming to understand these, in the end, quintessentially parental issues that I have sought to talk about. So I want to clarify that. Obviously, I didn't threaten anything with anything more. I wouldn't put it like that, but if you want to characterize it as such, I mean, that's a loaded word that I don't have to tell people gets contorted quite a bit. But the threat, if you insist on calling it that, was merely that if actions in violation of law by judicial actors and private actors capitalizing on that were to continue after I had politely asked that it cease countless number of times, that I would redouble my efforts to evidence same and and to hold those accountable, those who are responsible for it. So I think the video speaks for itself. I posted it on Facebook. I took it down simply out of an extreme abundance of caution, to the extent that in any way it could be considered a threat. I think it probably goes without saying that it would be foolhardy for me to do anything in this space without kind of running it by people who have considerable expertise in the areas of what is permissible speech for somebody like me, who wears two hats, one as a parent and one as a lawyer. And if I violated something, or somebody thinks that I violated something like that, there's a reference to referring the matter to the Commonwealth Attorney. I'm not quite sure what that's about. Not quite sure what the court's authority is to do something like that. But in any event, I would just point out that, quite obviously the court is aware the FBI has a head start on this stuff, considering that FBI agents have been present at prior proceedings in the case. So the Commonwealth Attorney, a state actor and local prosecutor, might be a little late to this party. So I'm not quite sure why that reference was contained, but I did want to clarify that. Again, I put on Facebook some emails, and they remain on Facebook, that represent, I think very clearly, private actors reaching out to judicial staff members for the purpose of asking for, a pre-ruling on certain motions that by law only the judge can make, and receiving from those staff members without consultation with the judge, quite clearly given the timing of those, the timing and larger context of those emails, receiving, private, rulings, if you will, from the staff member outside, without the knowledge of the judge, of a kind that clearly was not warranted by law, and we know that because those very same email messages, which I posted on Facebook, contain the entire string, and on account of the objection that we respectfully but stridently made, as we have, to that kind of conduct, for whatever reason, that particular staff attorney apparently saw fit to run those issues by the judge, and the judge, essentially reversed the relief, if you will, the rulings that had been made outside of his knowledge by the staff member, and without any legal authority to do that. So You know, it's I don't think that I think the bigger deal, and you know, just kind of judging by the reaction, you know, since then, in my personal experience, the bigger deal is not the fact that you know, I threatened, if you will, if that's the word that you want to use, to report public corruption to the authorities and to redouble my efforts to evidence it if those engaging in it continue to engage in it. That seems to be less important, I think, to most, certainly to me, in the tone of voice that I used in making clear how inappropriate and how violative of the public trust such behavior was. Again, all of this I put on Facebook so everybody could see all this for themselves. That seems to be less important than the fact that that was going on. So it is curious to me that that the video and the posture of my discussion of it would be characterized as such. I think it's far more important, obviously, that that sort of thing was going on relative to the manner by which I chose to address those engaging in it. Clearly it was going on. The evidence of it, I literally put on Facebook and consists of those emails, and anybody, I don't think you even need to be a lawyer to understand how damning and how inappropriate those emails you know, are, that what that evidence is. You may need to have some kind of particularized knowledge about the pre-hearing docket, but you know, those rules and that procedure is set forth in the local rules, and anybody can look it up. In any event, it is curious that there would be a discussion of, you know, a characterization that I made some threat. You know, I threatened to report those engaging in unlawful conduct who had clearly engaged in unlawful conduct, you know, to the people that you should report them to for engaging in the unlawful conduct. I don't know that that's a threat. In my view, that is a public service. But nonetheless, if in some way that is, you know, violative of some rule for attorneys, or God forbid for a public citizen, by all means I should be held accountable for that. But it just seems rather ridiculous, to be perfectly frank about it. Moreover, it is interesting to me that there would not be mention made in the order itself of the fact of the emails and what had happened. The fact of which is undeniable, is reflected in documentation, and such documentation is, you know, on the internet. I put it there. It's a matter of public record. The purpose this entire time has been to spotlight corruption, and I have said many a time, after even before that, saying many a time, this needs to stop. Can we just stop it? Just want to stop it. At some point in time, I certainly was more direct and very clear and transparent in saying, if this stuff is going to go on, I'm going to put it on the internet. And the public and those who are charged with maintaining the integrity of our public institutions can judge this conduct for itself. So, you know, obviously in doing that, I'm not doing anything more than living up to my word in that regard. I stand by all of that, and sure, yeah, I have some pretty direct messaging and choice words for those who would violate the public trust and do things of a kind that is evidenced right there on the internet, on Facebook, and now on our YouTube channel, Spotlighting Corruption. I don't know why it would be inappropriate in any way for a private citizen to report behavior that is in violation of the rules and quite potentially criminal. I think that we are encouraged to do that, and I would certainly think that that is a good thing to do. So I was confused about that aspect of the order, and I did want to speak to that, you know, briefly. I don't know the free characterization of bullying on my part. I guess it depends on your perspective. Have I been particularly insistent and unwavering and steadfast in my commitment to the rule of law, and that the rules of the court and that the law be followed in my case, in addition to other, you know, cases? Of course. I don't know that that's, you know, bullying, and to the extent that judicial actors are using the imprimatur of the judicial office to author orders or do other things that are inconsistent with the law, hell yes, I've had a problem with that. How that is bullying is not quite clear to me. And again, I mean, these labels are kind of loaded labels. The underlying conduct is undisputed, factual, and speaks for itself. So the public can judge, and the people can judge the actions for itself and can label it however they want to label it. Threat or public service, bullying or standing up for what's right in the face of corruption. I'll let the people make their own minds up based on the facts and the evidence that I've made available and put on the internet for the people. Those are the comments that I wanted to make in relation to the court's order last week indicating its recusal. I did want to have, I did want to make a brief comment about certain events that have transpired since that time. Since that time, the court's order in that case has been used, and certain materials noted or on which the court purports to rely in its order. They have been made available to certain court actors in my cases who will continue to have a role in my litigation with the new presiding judge. Let's understand this. That the presiding judge in a case is not the court. Let's understand this very, very clearly. This should be a matter of common sense, and let's be obvious about this. The fact that we have a different presiding judge in the case, it's not terribly uncommon. There can be many reasons for that, and let's be ever mindful of the idea that the court is not the same thing as the judge, and no man or woman elected to hold the office is the office. And it is probably a point worth repeating today in light of certain actions that have been taken by certain of the parties to at least one of my cases, one of which happens to be the Children's Law Center. The Children's Law Center was appointed as the guardian ad litem in one of my litigations. I don't think it's any secret that I have, hopefully respectfully, but stridently, both in the litigation and without, very much attempted to draw attention to the role and conduct of that actor and its representative in my litigations, and have made Facebook videos about some of the actions that have sought to be taken by that actor. I think very transparently in retaliation for me as a parent, speaking out and up about the need for reform of the guardian ad litem system, and using the actions of the Children's Law Center and its representative specifically in my litigation as an example of the bigger problem. But since that time, once again, we have the Children's Law Center's representative taking the court's order from last Friday of recusal by the presiding judge and circulating it to certain people that are themselves court appointed, that pursuant to orders of the court are not to receive such things. I was shocked, although not really, honestly. I wish I were shocked to see email correspondence last Friday after the court's order, I guess the previous day, November 4th, had been entered. That is an absolute and direct violation of the very plain court orders of the court. And I make this point once again to emphatically make this bigger point. I don't care what your name is. I don't care if you're Joe Schmo, Ben Duzing, somebody else, or the Children's frickin' Law Center. Okay, if you are appointed pursuant to law, you have very real legal duties and very real legal prohibitions, and we are all, myself included, but everybody else, no matter what your name is, accountable to the court, to the law, and to the people for complying with with your legal obligations. One of which, sure as hell, is to follow the clear orders of the court, which is different than a presiding judge, of course, in relation to the dissemination of materials of a certain kind. least in my case. And to do that is flagrant, shocking, unprecedented in my experience as a lawyer. Granted, this is not the space that I typically play in, and that's part of the adjustments for me. But we have court orders and they have to be followed. And the Children's Law Center is no exception. And given that the Children's Law Center is a guardian ad litem that, to my knowledge, is on the guardian ad litem panel, not only in Kenton County, but in other places as well. I could be wrong about that. It's just my understanding. This is a nonprofit organization that is, purportedly has as its mission, serving kids. There is nothing that serves kids about the flagrant violation of clear court orders. Hopefully we can all agree on this. So this is me bringing to the public's attention that we need to hold these actors accountable and correct these problems, lest even court actors that have such a role contribute to the problems with the system. I mean, let me speak very frankly. This is ridiculous. That's ridiculous. It's ridiculous. I'm not familiar as a lawyer of 20 years, and certainly not as a former federal prosecutor, with this idea of certain people finding clear mandates of the law as reflected in court orders to be optional. And I am certainly not familiar in my 20 years as a lawyer and 5 years as a federal prosecutor with the idea that there is no consequence when people who have clear legal obligations and prohibitions fail to comply, fail to do those duties, or do the things that are prohibited. That when we stop having accountability enforcement for anyone, that's extremely problematic. Those are the messages that I find it appropriate to deliver today. I would direct everyone's attention to a 50-minute video that I did late last night that represents, basically my best attempt in a hurried way of condensing and summarizing a lot of the issues that if I were a litigant in the Kenton Family Court or a lawyer representing someone in the Kenton Family Court at this time, which as of last week I am not, I would want them to know. And it just doesn't seem all that appropriate to celebrate my freedom, if you will, recognizing that the majority of my brothers and sisters, both as parents and as lawyers, remain subject to that kind of system. And I want them to have the benefit of everything I've learned, all of my knowledge, all of the data that we've collected, all of the evidence that we have, for the purpose of defending and protecting their own families and all the other kids that remain subject to that system. Our purpose is reform, nothing more. I am personally not disappointed with the fact that my personal litigations and the situations involving my children and my family will be decided by judicial forums that are not the Kenton County Family Court. But I am extremely mindful of the fact that this was never about me. It's not about me now, and it will never be about me. And so that fact in no way changes the mission, what we've set out to accomplish, and what we're doing, and the things that are planned and that we've advertised. So we're done when we've accomplished the mission, which is a family court, both the Kenton County Family Court and in general, that works for the people, that works for all people, and is for all